Okay. Hello, everyone. We're going to get started on the next session here. So please welcome Professor Susan Carls. She's coming from American University in DC, and she's actually a visiting professor at Washington and Lee right now. And I just want to, really thank her for coming out. There was a lot of trouble on the way here. Her flight got delayed last night, so she had to stay the night at the airport last night, and it was a whole thing. So very fortunate to have her here. So as I mentioned, she is a visiting professor at Washington and Lee College of Law and is a professor at American University. She writes about civil rights, legal history, employment discrimination, labor and employment law, legal ethics, and the history and sociology of the legal profession. She is the author of Defining the Struggle, National Organizing for Racial Justice, and she has published numerous articles in Harvard's Law Review and Fordham's Law Review, as well as others. In 2001, her paper entitled Race, Class, and Legal Ethics in the Early NAACP received the Association of American Law School's Best Scholarly Paper Award. And in 2006, she received the Jean and Edgar Kahn National Equal Justice Library Award for Distinguished Scholarship. So I want to welcome Professor Carl here, and I'll hand it over to her now. Thank you so much.
Thank you so much, Ashir, and all the organizers of this symposium and this wonderful, distinguished journal with its wonderful history and important contributions to the social justice cause. So Ashir asked me when I agreed to do this to talk for 35 minutes, but I feel like it would be better maybe to be a little more informal than that. So I have a 35-minute talk, but I think I'm going to just shorten it so that we could have more of a discussion. And what I'm going to be talking about is the racial justice movement, which is what I write about. But as you heard, I also teach labor law. I'm a former community organizer and a former union side labor lawyer. And so even though these two topics might seem somewhat separate, they're also very well connected. And there are historical reasons why we sort of think of the labor movement and the civil rights movement, the so-called civil rights movement, which I prefer to call the racial justice movement, as two separate topics. There's a history behind that we could perhaps get into in the Q&A. So I am thinking and writing now about the Reconstruction era. And when I was asked to give this talk, I started thinking about some of the lessons of the Reconstruction era for social justice movements today, and especially the racial justice movement. And so I'm going to sort of talk about that. That's my plan here. And I'm going to suggest, so we are in this sort of moment in which there are some bright spots, but many very concerning and troubling developments. And I want to sort of think about what all of that, and we don't really know what our future will be. And so I want to sort of think about some lessons, some historical lessons that might be important now, and particularly to focus on the Reconstruction era. So I don't want to at all suggest that the Reconstruction era and today are the same thing, right? I mean, totally, they're very different eras, very different situations, but I do think there are some important parallels that we might want to look at. And one is that the Reconstruction era, the creation of the civil rights statutes of that era and the 3 amendments to the Constitution that you've all studied in your classes also came out of a social movement, which was abolitionism, right? And so that is one kind of parallel. Abolitionism was about a lot more than emancipation. for most abolitionists, not all of them, but most of them, and most of them understood that the real goal was civil rights equality. Today, in fact, emancipation itself is not a finalized thing, and we heard Samir and the other speaker this morning, Mr. Moose, talking about the theme of abolition. So there's a lot of really interesting work being done now around the ways in which the 13th Amendment still needs to be given much more life. So we also are in both situations in the Reconstruction period and now, we're confronting extreme racial injustice, brutal racism, violence, and stark political, legal, and economic injustice. We're in both eras, there are really a lot of complexities to the movements involved. There are radicals, moderates, and then relatively conservative members of social movements. And there are tensions among the perspectives of various of these groups and leaders. In both eras, leaders of color who had experienced racial injustice firsthand sometimes disagree with white advocates who are well-meaning, but sometimes slower to perceive the situation at hand. So on the topic of racism, then during the Reconstruction era and now, this country was deeply, viscerally, and violently split in political opinions and values. The divisions of today between racist far right and progressives on the other side of the political spectrum have very direct roots in the violence and conflict of the Reconstruction period. And I don't think we spend enough time thinking about this. The ideas and ideologies of those who opposed equal rights and citizenship for Black persons after the Civil War have been transmitted, and I calculated this, it's like 6 generations, to provide the basis and sometimes the same arguments for the racist far right today. And of course, this is very concerning because it shows how deep and resilient virulent racism is in the United States, and especially as it's emerged from its hiding place under President Trump. And just an example of this, even though the national media and the local media is trying not to play up the Beltway situation, the truck convoy, I have run into it a number of times. And it's a mix of American flags and Confederate flags, and it's a mix of anti-mask mandates and anti-vaccine and Lynch, Fauci, and all this other stuff. But there's also a lot of racist stuff that you see, and it's huge. That the number of people who are doing that, it is extraordinary. And I'm sure you have the Minnesota equivalent, so I haven't been following your local news to. So I want to point out that racism and this kind of conduct, this kind of ideology is national. It's not regional. And one of the reasons I wanted to go to Washington and Lee to visit is it's in the heart of the old Confederacy. And I wanted to see what it was like. And so down there, I do see Confederate flags, right? And they really make me shudder. But I live in the summers. I've taken to spending my summers in the Adirondacks in upstate New York. And here's a picture of one, Confederate flags up there as well, right? And I hear people saying incredibly racist things. So it is important to sort of think about this sort of national nature of the rise of the racist right. Then and now, huge problems with violence. Of course, the violence today is nothing like it was in the Reconstruction era, and I'll talk a little bit more about that in a minute. But it is true that a major mechanism of racism is violence. So some more parallels. Then and now, and this is one of the most concerning aspects of the present period, I think, we are facing a hostile court, right? So in the Reconstruction era, as I'll talk a little bit more about in a minute, the US Supreme Court was no friend of the racial justice cause. The Chief Justice in the Reconstruction era. The first one was Salmon Chase, who was an abolitionist and who was a member of Lincoln's cabinet and was sort of trying on this front, but he was outvoted by the rest of the court, and then he died. And after that, a new Chief Justice named Morrison Waite came in and eviscerated a lot of the legislation and narrowed the interpretation of the Reconstruction era amendments. I think we're facing exactly that situation today with the court that we have today. More parallels still. We have an executive branch that is either hostile, has been hostile to, and now seems to be fairly powerless around racial justice issues. So as you probably remember from your American history, after President Lincoln was assassinated in 1865, and this extremely hostile new president, Andrew Jackson, became the president and resisted as much as he could the efforts of the Reconstruction Congress to make progress on racial justice equality. Then President Grant came into office, and things did get a little bit better under him, but then he only served for one term. And after that, in the compromise of 1877, the Reconstruction was ended for all intents and purposes for, arguably 100 years. So we have a situation in which the court is dismantling the sort of jewels of that Second Reconstruction period in the 1960s, eviscerating the Voting Rights Act, and probably poised to do even more. And Congress has not proved itself to really be a strong ally here. It could go back and reenact the act in the face of Shelby County v. Holder, which I assume many of you have read in con law. But we don't have that sort of alignment of the executive, the legislature, and the judiciary that was the reason, that sort of very rare alignment of the stars, that was the reason that allowed all the progress of the 1960s with the statutes that were vigorously enforced by the court and promoted and supported by President Johnson. Those dynamics do not exist today. So I think these similarities point to some lessons that we can draw by thinking about this, the comparison of the two historical eras. But I'm going to start just by talking a little bit about the sort of basics of Reconstruction, because when I was a law student, I was a little fuzzy on them. And so I think it will help illuminate the lessons if I just talk a little bit about the history here. So, okay. So, early years of Reconstruction. So historians typically date the beginning of Reconstruction, meaning the process of reconstructing the South destroyed by the Civil War, to the end of 1863, when Lincoln announced his proclamation of amnesty and Reconstruction. And at first, Lincoln tried to be quite conciliatory towards the South, promised pardons and a return of all property except formerly enslaved persons to those who had participated in the existing rebellion, provided they simply swear that they would henceforth support the Constitution and the acts of Congress and the president. But the radicals in Congress had a very different stance. 5 days after the president's announcement, they began introducing these constitutional amendments. In March of 1865, both houses had already adopted the 13th Amendment, and then Congress passed its first Friedmans Bureau Act, which established the Bureau for the Relief of Freedmen and Refugees, by which were meant white refugees of the war, to last through the war and for only 1 year thereafter. It was extended a few more times, but not for that long. The agency was charged with managing abandoned lands, providing food, clothing, fuel, temporary shelter to freed persons and refugees, to make reports to Congress, to investigate violence, to set aside tracts of abandoned land within insurrectionary states for the use of freed persons. And this, of course, was one of the great tragedies of Reconstruction, in that that promise was not one that Congress followed up upon. Thus, being one of the great missed opportunities of the Reconstruction era. Many scholars have pointed out that the Friedmans Bureau represents the first U.S. experiment in government-provided social welfare resources to foster human flourishing. And we heard a little bit about community prosperity on the panel that the wonderful panel we just heard. And so, this is all part of a continuation of ideas about the need to provide not only for civil rights, but also for economic and social rights and flourishing. So just want to point that out. So Johnson, of course, detested the Friedmans Bureau acts and tried to squash them through his veto power, but Congress overrode him. Johnson argued, quote, "A system for the support of indigent persons in the United States was never contemplated by the authors of the Constitution, nor can any good reason be advanced why it should be founded for one class or color of our people more than another." And of course, Johnson was correct that the original founders, had not contemplated the need for a social welfare system, but he was incorrect that such a system would necessarily protect only one class of persons, as shown by the very fact that the Reconstruction Act covered both white refugees and freed people. But he did put his finger on this original flaw in the design of the Constitution, which is that the U.S. government, it was recognized by the 1860s that the U.S. government really needed to recognize rights to and provide for certain basic resources needed for human flourishing in order for equality and civil and political rights to be achieved. Unfortunately, Congress did end the Friedmans Bureau for most intensive purposes, though it did have a longer existence in providing for educational institutions. But other than that, it was ended in 1868. But its short existence does highlight this lesson that social welfare legislation has to be part of a racial justice agenda. Of course, state ratification of the 13th Amendment occurred by the end of 1865, but Congress already knew that simply abolishing slavery through a constitutional amendment was not going to end slavery-like practices. Southern states began to enact so-called black codes, which imposed oppressive new forms of subordination on Black persons by limiting freedom in movement, residency, employment, association, really draconian restrictions that reduced freed persons in many communities to a condition only a little bit better than enslavement. And so it became clear, even to very moderate Republicans in Congress, that more would be needed in order to achieve civil rights and human flourishing for freed people. And that led to, of course, the passage of the 14th Amendment. And so the language of the 14th Amendment, which really is so confused, right, is the reason why we're having this terrible debate around substantive due process today, and who knows where that's going to end up. So it did not really reflect all the goals of the radical Republicans, and I've spent a lot of time reading the debates in Congress about that amendment, and happy to talk about it later. And it didn't address political rights. And so Thaddeus Stevens, who was one of the great radicals, one of the great visionaries of the Reconstruction Republicans, radical Reconstruction Republicans, nevertheless urged his colleagues to approve it. And he explained, "I had fondly dreamed that in this moment we could have remodeled all our institutions so as to have freed them from every vestige of human oppression, of inequality of rights, of the recognized degradation of the poor and the superior caste of the rich. But my bright dream has vanished. I find that we shall be obligated to content ourselves with patching up the worst portions of the ancient edifice. But I accept so imperfect a proposition because I live among men and not among angels. So Stephen saw that Reconstruction had presented this wonderful opportunity to bring in a new structure of government that would address the root causes of inequality, based not only on race and former enslavement, but also on poverty and, quote, every vestige of human oppression. But political reality had killed his dream, though this broader vision of using law to defeat caste would be transmitted to human rights movements and social justice movements far into the future, including all the movements that we're going to talk about in such a wonderful way today. And I meant to say I really commend the symposium organizers for the way you've really sort of picked the key aspects of this moment and the need for this sort of integrated social justice advocacy. Then after the 14th Amendment was enacted, Congress started passing Reconstruction Acts, and one of the reasons it did that was because it couldn't get the southern states to ratify the 14th Amendment. So what Congress did was to put all the southern states under U.S. military authority and require those states, in order to gain readmission into the Union, one, to allow men of color, of course women didn't vote no matter what their race, but to allow men of color to vote, to have federal supervision over voting, and required the states to adopt new republican constitutions and government structures. And very importantly, states were required to ratify the 14th Amendment in order to be readmitted into the Union. And I never actually knew that or focused on that before. And so that is why we have the 14th Amendment today. Without that sort of really hardball pushing of that the Congress did as to these states, we would not have a 14th Amendment. The Reconstruction Acts and passage of the 14th Amendment met, of course, with very strong resistance from these covered states, and that resistance included violence and other extra-legal as well as law-based means of voter suppression. But nonetheless, Black men did vote in significant numbers. And the fact that they did changed the former secessionist states' political landscape. Historians estimate that about 400,000 Black men voted during Reconstruction, and approximately 2,000 Black men held political office in the southern states. So finally, in the summer of 1868, the final state needed ratified the 14th Amendment, which was Georgia. And then Congress readmitted the Confederate states, the ones that had ratified the amendment, which wasn't all of them quite yet, that took a little longer, and allowed their formerly excluded representatives to vote in Congress again. And so by playing hardball, Congress achieved its objective of 14th Amendment ratification, but there was a catch-22 in the strategy, because now that the resisting states had obtained readmission into the Union, they could exercise their political influence against congressional Reconstruction. The other kind of hardball tactic that Congress tried was impeaching the president. And we can talk more about the details. I'll skip the details, but it did, the House impeached, and the Senate failed to remove him from office by one vote. So again, hardball tactics, and all of the actors were using them: Congress, the president, and the secessionist states. The Reconstruction Congress seemed to have achieved its objective of adding civil rights protections to the Constitution, but failed to take out the obstructionist head of the national executive branch. So an experience proved fairly quickly that even the 14th Amendment was not going to secure long-term protection of Black person civil rights. And there were very high levels of terrorist violence that continued to take place. And this is Brian Stevenson's group did a chart of looking at the Friedmans Bureau reports of violence, including large-scale massacres in certain cities, and smaller acts, including sort of night riding, where terrorist organizations would go out under cover of night so they wouldn't be detected, and so as to inspire maximum fear. So you can see that the violence spread in many areas. It wasn't just confined to the sort of, the heart of the Confederacy, but there was a lot of violence. So this massive resistance was what finally, again, forced the more moderate members of Congress to decide that they needed to enact yet another constitutional amendment, the 15th Amendment, in order to protect for all time, was their hope and intent, the right of Black men to vote. At first, the moderates had rejected putting voting rights into the Constitution, but as this violence continued, they really quite quickly changed their minds. And so a congressional majority realized what Black abolitionists had been saying all along, which is that no rights can be safe without the right to vote, run for office, and otherwise exercise political power. The nation's original founders had thought that the political elite could be counted on to protect everyone's rights, but the nation's experience with brutal racism showed that the civic Republican idea about how government would work was flawed, and that elites often act to protect their own interests and have racism in their hearts, and don't always act to protect the public interest, or often, usually do not, so that all persons needed to have the right to vote and exercise political influence in order to protect their own interests and allow democracy to work. So unfortunately, the amendment that Congress adopted was much more narrow than a sort of universal right to vote. They considered a lot more broad language, but in the end, they adopted that narrow language that we all have read, which simply bars discrimination on the basis of race in voting and still leaves, under the federalist system, up to states to sort of figure out what they want to do other than that. And so that amendment got ratified within a year of its adoption in 1869. And ironically, but importantly, the fact that Black men were voting in southern states was the reason why. So the ratification of the 15th Amendment was much easier in the South than in the North, because most states in the North, especially states that had significant minority populations, had discriminatory voting rules. Like California is an example, New York is another example. New York initially wouldn't ratify the 15th Amendment, and their state politics changed, and they did eventually ratify it. But there was plenty of racism and discrimination in non-Southern states. And so, a lesson as we think today about where does racism come from and where is it located in. So like the 13th and 14th Amendments, the 15th Amendment really placed a lot of faith in the US Supreme Court and lower federal courts to enforce the legislation that Congress would promulgate under the enforcement provisions of those amendments, which you've all studied in con law. And Congress did use that enforcement power to enact the what are called the Enforcement Acts. One of them, which is now then and now known as the Ku Klux Klan Act, and still survives in part today, provided for federal criminal prosecution of persons who violated citizens' rights to vote or other fundamental rights, or to serve on juries, or otherwise enjoy equal protection of life, liberty, and property. And President Grant, when he took office, supported federal prosecutions of the Klan. And I never knew this before, but that was why the Justice Department was initially created in his administration. And this work produced a relatively impressive spate of indictments, totaling somewhere between 1,000 and 2,500 cases by the early 1870s, along with 600 convictions. And that work, according to experts like Eric Foner, who studies Reconstruction, really succeeded for a time in crushing the Klan. But it unfortunately did not continue under later presidents. So unfortunately, that was the 15th Amendment. Unfortunately, right around this time, we saw the end of Reconstruction. And so that happened partly through the Supreme Court, which was proving itself to be an enemy of Congress's intentions for the Reconstruction era amendments. It's a complex story. It's discouraging. I'm going to skip the blow-by-blow details, but I'm happy to talk about it during Q&A. And then the Compromise of 1877, which resolved the disputed election for president in 1876, led to the selection of President-elect Rutherford Hayes in return for him promising to terminate Reconstruction completely by withdrawing all federal troops from the South and allowing the Southern Redeemer Democrats to take over state governments throughout the South. So then, to fast forward really quite quickly, I've written a book on this period, but the so-called Nader period occurred, right, from the 1870s all the way up to the 1930s. And things only gradually started to improve just a little bit in the 1930s and on, and almost a century would pass until the inception of what is sometimes called the Second Reconstruction with the enactment of the Civil Rights Act and the Voting Rights Act. So in telling this story, my point is this: national level politics are very fickle, and under our system of government, it is very rare for there to be a convergence of the kind of forces where we truly make progress on contentious issues like racial justice. And so I want us to keep that in mind when we think about the future of social justice activism and racial justice activism. And I have 6 lessons I want to suggest from this story, this narrative I just told you. First of all, I would suggest we should not place too much faith on words on paper, right? Even when we spend so much time studying those words in law school, as we should, because words are important, but they're not enough. So a lesson of Reconstruction is that the radicals, Republicans, needed both words on paper and the support of the court and the executive and Congress far into the future. And that's rare that that's all going to align in the way that's necessary. So I want to urge public intellectuals like yourselves, as you're going out to be, as you're generating ideas about how to put forward racial justice goals, to avoid engaging in naive faith in law in the books. We should wean ourselves from the habit of looking to the court for progress on racial justice issues, or from venerating the court without more as a source of progress. Of course, we need to fight hard to protect all the 20th century doctrinal developments that are at risk now and being demolished all over the place. But doctrine is not sufficient. And doctrinal tweaking, I think, is unlikely to result in much change given the present court and its ideological and political commitments. And I just for fun asked my research assistants to do a survey of articles being published in law journals, and in the top 10, which includes the Minnesota Law Review. And Minnesota, this was not true of, but many of the other top journals have a disproportionate number of articles that are about the Supreme Court, federal courts, and sort of this very doctrinally focused perspective, which I think is not going to get us very far today, but it is sort of in style for reasons that have to do with sort of the social moment or whatever. A second point that I've already sort of hammered in presenting my narrative is the need for hardball politics. And I would argue, contrary to almost everybody I've talked to about this, that packing the Supreme Court is one of those tactics that we really need to think hard about. Interesting that in the Judge Jackson hearings, she kept getting asked about her views about packing the court, and she was very good at avoiding having to answer that question. But really, that does seem to be the one strategy that might make a difference to what the court is going to do to the legacy of civil rights doctrine. We'll see. Also, and I was so excited to learn that you have local prosecutors coming, progressive prosecutors. I think one of the things we can see from the Reconstruction era is that prosecuting civil rights violations really does matter, right? And that's something that racial justice advocates should focus on. It hasn't been traditionally the strategy of the racial justice movement to go to prosecutors. But I think in this period, and especially with the development of the progressive prosecution movement, that this kind of alliance is really important and will make a difference. And the lack of it possibly is responsible for things like the January 6th debacle, and now those people are finally getting prosecuted, but maybe there should have been more attention paid earlier on. Lesson 4, promoting social welfare rights, right? It's not like these are two separate things, racial justice and social welfare rights. Lesson 5 is really focusing on the fundamental nature of the right to vote and making that really a central priority. And of course, we have seen so much backsliding around preventing states from adopting voting rules that diminish the power of racial minorities in the electoral system, but something that really needs attention on the state and national level. And then finally, I want to suggest that we really need to study new ideas about how to use law to counter racism. And what those ideas should be, really, it's a question of sort of political philosophy and social psychology and law. There are a number of movements, the democratic experimentalist movement, which I used to be kind of against, but now I'm starting to rethink my view about it, the idea of sort of experimenting with soft law and hard law, collaborations, rolling rule regimes, reg-neg, participatory, creation of rules. There's a lot of interesting work that's being done both in the international area and in some areas domestically that we should look more at. Maybe there are things that we can do that are around the area of just law as dictates that courts enforce. And also social neuroscience, which is producing a lot of interesting new ideas about how racism gets embedded in the brain and maybe how certain kinds of trainings can kind of dislodge it. Let's look at all of that stuff and see, what are some new ideas instead of using ones that haven't worked. So in short, there's a lot to do, and I think it's important that we don't merely repeat history at this critical and concerning moment, and I really welcome hearing your ideas about how to use law and social movements to advance the centuries-old racial justice project.
Q&A now, if that's okay with you, Professor Carl.
Yeah, perfect.
If there aren't any questions, I actually have one myself. So I think as a law student, especially as like a law student in color, I look at precedent and like history, like you've shared with us today, as something that's kind of, for lack of a better word, like depressing or containing of the kind of movements and results that we want to see. Is there something, whether it's within the law or with activist movements, that you look to as a source of hope for the future?
I think it's people. So the book I wrote was about racial justice advocates, most of whom were African American, really all of them, during the Nader period, where nothing was happening. These are people you probably haven't heard of for reasons that are, the way that power constructs history and everything, but they, in the bleakest conditions, right, they were hopeful about the future, and they were experimenting with what were at that time new strategies. And at the time, the strategies didn't really work all that well, but they kept going at it. Again, they reflect, like, what went wrong, let's try this, let's try that. And when the conditions were ripe, right, in the sort of it started in the beginning of the 20th century and then as it grew, they had all of those ideas teed up and ready to go. And so that was really, without all of that work that was going on during really depressing times, the civil rights movement would not have been able to take advantage of the moment that came along for progress and change. So I would say more than anything, it is the organizing. It is the people who are really committed and dedicated to figuring out new things. It's the Samir's and his students and the Abood project and all of that kind of work that just, it sort of seems small scale now, but when the time arises, it's going to be that work that's going to be able to move into, a moment to really, to make change. So that's what I would say. More than, and I think that's, as important or more important than, the elite public interest organizations that are litigating test cases and that kind of thing. I think it's really what's happening in a more local way that's new and experimental and is, looking at things like workers' centers and other kinds of new experiments. Yeah.
Yeah, so it's something actually I think about a lot. Here's your thoughts on it. It seems to me there's a lot of tension between sort of this, particularly in the field of law, between sort of the norms of the profession, which is legality and sort of working within the system, and then how things get done in the real world, in the historic areas you're talking about, which is that it does require this hardball politics. Something like packing the court is horrifying. You have to whisper it in a law school because so much of it is built around respect for the court.
Right.
And how do you this tension comes up all the time. There's pressure to keep quiet, to work within the system, work with existing institutions within the institutions themselves. Unless we're going to change these things. And I'm curious how do you see this as this sort of how do you resolve that?
Yeah, good question. Well, I would say that you don't have to shout at people, but I do think I do think that there's, unlike what was happening in the confirmation hearings, that awful behavior, there is a way of being really forceful and consistent on one's goals and strategies that doesn't have to go along with being an utter jerk, right? So I have a little bit of a criticism of the civility movement for the reasons that you just mentioned, right? That sometimes civility means that those people who are pushing for the rights of the less powerful are seen as not sort of playing the game and not being sufficiently collegial. And there's a lot of empirical work on that, like women lawyers who in divorce proceedings who were representing women, and they were considered by others in the community as being too aggressive and not, not following the norms of the profession around things like you don't question the financials that the other side gives you. But these lawyers were discovering that those financials actually were often misleading. So I think that being forceful but being really rude don't have to be together. But I do think that we should be forceful and we shouldn't. It's very easy if you're representing those with a lot of power and privilege. It's very easy to sort of accept the status quo and just get along. And if you're not, it's a lot harder, right? And one of the things people will use is this idea that, you're being too aggressive, or you're not being polite, or you're not observing the norms of lawyers in this community. And I think you can't listen to that. Yeah. Yeah, and I do think that we do really, and I teach con law, so we really do venerate the court in this way that, well, first of all, if things continue the way they're going, I think the court will destroy its own authority and its stature. But I don't think that law schools need to be the last bastion of critique of the court and the role of the court and the necessity to focus elsewhere than the court for change.
Susan, can I
Yes.
ask you just in response to the last question, we in our legal profession class will teach
Yeah. So I have an article where I suggest that sort of as lawyers think about where their sort of position should be on the aggressive versus accommodating, or thinking about public interest versus aggressively asserting for clients on that spectrum, that as the power of your client declines, is important to be more assertive and aggressive. And when you are representing clients that do have a lot of social power and privilege, in those kinds of representation contexts, it is important to really focus on the public interest ramifications of the kinds of things that you're doing for your clients. So it's sort of like a reverse sliding scale for all the reasons that you mentioned. Yeah.
I think, the thinking about the Reconstruction era, I feel like there's this sort of counterfactual of a even more assertive Reconstruction, right? Where the former leaders of the Confederacy were, not allowed to continue in public life, or,
Right.
a really muscular Reconstruction.
Right.
That's often, I think, thought of on the left, like what could have happened
Right.
if we had really
Right.
been strong about this.
Right.
But I often wonder too, like there's this terrible heckler's veto in American history, and whether that would lead to like a continued Southern insurgency, if there hadn't been this reconciliation process.
Yes.
And I just wonder, even in today's era with
Yeah.
like the January 6th situation,
Yeah.
there's this balance between trying to reconcile this, minoritarian, conservative aspect of the society, and just trying to like prosecute it and
Right.
take it on. And I wonder, I don't know, that's not really a question, but
No, I
in your
understand
research
what you're saying.
history, what do you think? Do you think that would have led to more violence, or do you think, it's hard to deal with counterfactuals, but.
Yeah, it is, but I know what you mean. I understand it is a really tricky question, I think. What happened in Reconstruction that led to sort of the compromise of 1877 and the withdrawal of federal troops is there wasn't national support anymore, right? And all of the radicals, were dying. The radical generation had kind of, ended, and even the Republicans there was a recession, and the Republicans were kind of focused on issues other than civil rights equality, and so it wasn't, there just wasn't the will. There just wasn't the will. The political conditions were not such that, that period and those goals and that energy and commitment could continue. So I've thought different ways about it, but as I've been studying this period, I do really think that the prosecution of violence mattered, right? And that we should be really focused on that now. And of course, a lot of prosecutors are, and Merrick Garland, who seems to be just very slow and not very powerful about anything. He's said he's committed to these things, but he's not really pushing as hard as he could. But I don't think, and Lincoln had started off thinking that conciliation was really the way to go, but it turned out it wasn't. And so I'm not sure. I actually, as I think about your question, I think it probably is not. But which is not to say that you can, that this is why I suggest that we need to think about other ways of using law, because mere prescription is not going to stop the things that the law is trying to prescribe, right? I mean, merely saying, it is illegal to violate someone's civil rights, or, the state should be paying attention to protecting civil rights and all of that sort of stuff. That did not work in itself. So we need to figure out ways to reach hearts and minds and to pull people in, like organizers do, pull people into participating in these processes of creating laws. And that is not happening today, right? We're just split into these two camps, and there's sort of no, not everybody who's, well, I don't know. I mean, we need to, we've sort of lost, and this goes to the labor part, we've sort of lost the white working class completely, right? They're just gone. They've just turned into sort of reactionary bigots, it seems like. Or not everybody, of course, but so there needs to be some way of, and then this, I think, goes to the importance of organizing around shared interests. And there are so many shared interests that people have, and so some sort of way of bringing people together, thinking about law, making law, and developing new norms and practices, we got to work some of that out. And what I'm saying is, let's try to think about that kind of stuff instead of thinking about, if we tweak this Supreme Court doctrine just a little bit, will that help? Because it's probably not going to help. But yeah. Tamir.
I had a few questions. One was kind of gets at this, what you're talking about, this organic element, grassroots. And I was wondering if there are lessons from the abolitionist movement in the years, decades prior to Reconstruction, when the moment opened up, that can tell us something about how movements really.
Yeah.
That's one. There's a reason Thaddeus Stevens is in a position to sort of accept the 15th Amendment. We can think about it as AOC at some point being in a position to accept something, that might be a consequence of a decade or 2 decades or 3 decades of grassroots movement work. And so if you have any thoughts on that.
Wow.
And then the second question has to do with prosecutorial power and the dangers of prosecutorial power. We're going to hear about the potential of prosecutorial power later today, but I think there's, within criminal justice and abolitionist movements, there's a lot of suspicion and antipathy towards the use of
There
prosecutorial
is.
power as a means by which to get justice. And so that's a little bit out of accord with
I agree.
one of your lessons,
Right.
in part, I think, because of the fear of the way in which prosecutorial power can be turned and used against people of color.
Yeah.
And certainly we saw attempts to do that during the Trump administration. If there's a second Trump administration, there will be much
Awful.
more of that. So if you could just talk a little bit about that internal, maybe, sort of dissensus with
Right.
regard to the use of prosecutorial
Right.
power.
Well, those are both amazing questions that I need to go back and think more about. But one of the reasons I'm mentioning, when I've given this paper a few times, or variations on this, and I gave it at Duke, and students were pushing me about the violence part, because I was talking about violence, and they're like, well, what do we do today about the violence? And it was at that point that I realized, we are going to have, and I'm not a big pro-prosecutor person, and I'm a little surprised that I'm saying what I'm saying, but it did lead me to realize that despite all of the points that you make, which are all very well taken, and we do need to be very careful, and who has that power and how that power develops matters a whole lot, but it is not a good thing to allow violence to occur and continue and grow and sort of mushroom, right? Without the state cracking down on it, because it is unacceptable, right? And to the extent that the security and life of certain group of people is not protected, that is just an incredibly dangerous situation. So I agree with everything you say about the importance of being, careful and reflective about it. But I think the idea of just sort of saying, well, we don't really like the heavy hand of the state cracking down on people. I think that in this moment, I don't think that's the right strategy. And it wasn't the right strategy in Reconstruction. And there were gains made. And if only those prosecutions had continued, we may not have the sort of big right-wing Klan-like and Klan-affiliated movement that is, circling the Beltway in DC today. So I think it's really concerning that at this point, among a number of imperfect options, the option of using prosecutorial power is really important. And then I love the analogy between AOC and Thaddeus Stevens. I just love it. And I want to think more about it. And I think it relates to the panel we're having this afternoon on environment and its connections to social justice. Okay, it looks like it's time to stop.
Yes.
Okay.
Whenever.
Okay.
Fantastic
All right.
discussion, but lunch is ready, I believe, so.
Yeah, we invite everyone to just stay in here and have lunch. We have pizza and Jimmy John's, chips, drinks, snacks. For speakers, if you want to meet Posher, we'll take you to the green room to pick out your lunch.
Okay,
And
All right.
then, so we'll bring pizza in here and feel free to dig in.
great. And thank you all. The questions were really wonderful. And I look forward to continuing this discussion throughout the day.